in a medical malpractice case, in a personal injury case, in a wrongful death case in New York, during the course of a pretrial deposition, a question and answer session given under oath, why is the defense attorney permitted to ask you so many questions about your background, having nothing whatsoever to do about the facts of what actually occurred? Would you like to know the answer? Come join me for a walk around the lake as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. Any time that you bring a lawsuit, now your life becomes somewhat of an open book. The defense will know all of the medical records. They will know all the medical treatment that you received. Why? Because we are obligated to give them copies of the records as well as give them permission slips so that they can go ahead and get copies of your records on their own. So they will have an opportunity to go ahead and read and review all of your medical records before you are actually questioned. So they will know all that. Now, they might also have done a background search on you to get information about your background. And now, during the course of your pretrial question and answer session, they will have an opportunity to ask you, either in person or on a Zoom video call, questions about your background, questions about things that you've done, as well as your medical history. You might be saying, wait a second. If I'm bringing a medical malpractice case, why does the opposing lawyer have an opportunity to question me for hours about things that have nothing whatsoever to do with the actual events that led to this lawsuit? And the answer is because this is known as discovery. This is the discovery phase of your case. When you start your lawsuit, the defense knows absolutely nothing about your case. They know nothing about the details. The document that actually starts your lawsuit might give them an inkling or a hint of what your case is about, but it's often short on details. A few months later, we have to prepare another document called the Bill of Particulars that itemizes exactly what we believe was done wrong, as well as what specific damages and injuries you suffered as a result of that carelessness. That document will give the defense a great deal more information about the specific claims that we are making, as well as the specific damages that you suffered because of this person or this entity's carelessness. However, when they get to question you, they don't know in your own words what exactly happened. They only will know what information their own clients and their own hospital staff gave to them about what they recall happening and what they recall based upon the notes and the records. There's going to be a significant amount of information that they will not know about. They won't know what happened to you from your perspective. They won't know about details about conversations that you had with various people who were involved in your care and treatment. They won't know any of that. And importantly, they will not know specifically how your injuries have affected you on a daily basis. And that is why your deposition is so critically important, because it gives the defense a clear understanding, or it should by the time they're done questioning you. They should have a clear understanding of exactly what you believe was done wrong, assuming you have an idea. Many times injured patients, injured victims do not. But it will give them an understanding of what it is that you recall. So now, when they go ahead and start questioning you during this pretrial question and answer session that lawyers call a deposition, they also call it an examination before trial, there is a court stenographer there to record all of the questions you are asked and all of the answers that you give. The answers that you give actually represent your sworn testimony, and it carries the same exact weight as if you are testifying in court in front of a judge and in front of a jury. And now you're being questioned by the defense attorney, and they spend the next hour and a half asking you background questions having nothing whatsoever to do with any of the facts surrounding your case. They want to know where you went to school. They want to know your highest level of education. They want to know what type of work you did, how much you were earning. They want to know if you were married. Do you have children? What do you do for fun? What kind of hobbies did you do beforehand? What type of activities did you do before with your family, with your spouse, with your kids? They want to know what you did with your income, what your expenses were. And they will go into exquisite detail about all these minute things that we consider to be, or you may consider to be, minutia, having nothing whatsoever to do with your case. However, here's something you may not know. Many of the things surrounding your background are important. And from the defense's standpoint, it's important to understand your damages, because they will uncover whether or not you were working. For example, if you bring a claim for lost earnings, it's important for them to understand what type of work you were doing before, what your roles and responsibilities were, how much you were earning, what perks and benefits you had, compared to now, compared to what you are able to do or not able to do currently. And they will explore all of that in great detail. They will also want to know your medical history. Was there something about your medical history that you failed to tell any of your treating doctors about? Because they will often argue that you may have not told your treating doctors about one or more of the things in your background, in your medical history, and I guarantee you they will claim that had their doctor known about this particular background, this particular medical history of yours, he would have treated you differently, and then your outcome would have been different. So they will explore whether or not you have a medical history and what doctors you were seeing, what medications you were taking, where you get your prescriptions filled, on and on and on. Again, none of this has anything to do with the facts surrounding how you suffered your particular injury. So again, you might be saying, I don't understand. Why am I being subjected to all of this nonsense questioning having nothing whatsoever to do with the facts? Because it's an attempt by the defense to learn details about you. They want to understand what type of witness you will make at trial. They want to know your background, where you come from. They want to know your history, so that if the case ultimately goes to trial, they will have an understanding as to what type of witness you will make in front of a jury. Will a jury like you? Are you sympathetic when you answer questions? Or are you a hothead? It's very important for the defense to be able to understand whether or not they can push your buttons by asking the simplest of questions, even though they're unrelated to the case. Why? Because if you start getting angry and upset about something insignificant in front of a jury, now they know they can manipulate you in order to gain favor and sympathy with the jury. That's very important. So going back to the question I raised at the beginning of this video, why are they allowed and why are they permitted and why will they go ahead and spend all this outrageous time talking about or asking you about your background? Number one, it's discovery. They are entitled to ask you those questions. Number two, they need to know if there's anything in your background that might have altered or affected the doctor's care and treatment of you, and whether you had disclosed all of those details to your treating doctors. Then they also want to know what type of witness you will make just by answering simple questions. Are you pleasant? Are you nice? Are you respectful? Do you understand the legal process that they have a right to ask these questions unless your attorney voices a specific objection and directs you not to answer the question? In most cases, you will be told you have to answer the question. And there are some exceptions, but you have to follow your attorney's lead and listen to whether or not you have to answer the question. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.